much. First of all, I want to thank you all for coming after the lunch and to stay with us till this very last session. I'm very honored and pleased to have this opportunity to speak in front of you today. As you can see, today I will present you, I can say, a continuum of the previous work that my colleague, Associate Professor Marta Dragičević Prtenjača, has presented here before you. And my part will be to give you a brief overview of the rights of the child in public law from a Croatian perspective. As you will see, all the results you can have the opportunity to read it in our paper. So today I will give you a brief overview of our current situation, and I think that you will see that we try to give you not only the legislation, but we also try to connect what is the current situation in our practice, to give you some data and maybe to emphasize where are our problems and if there is a room for improvement, which there always is. As a beginning, first I would like to tell you more about the terms that we are using in Croatian criminal legislation regarding children. All of us, when we speak about children, we are usually thinking that we are using the Article number 1 of the UN Convention on the Rights of the Child, that a child is every person under the age of 18. But as you can see from the previous presentation, for example, in Czech Republic, in other countries, there is sometimes a distinction between the term child and the term juvenile. We have that same distinction in Croatian legislation. So when I talk with my students about children in Croatian criminal legislation, I refer to all children who are under the age of 14. Why the age 14? Because in Croatia, age of criminal responsibility starts with the age of 14. So all children under the age of 14, if they commit something that could be considered to be a criminal offense, they will be transferred to our social services. On the other hand, here you can see that I've drawn you a little bit what age groups do we have in our legislation. So it's a very traditional that we have distinction between younger and older juveniles. Why? Because in Croatia you cannot be sentenced to juvenile prison if you are not older than 16 years of age. And here I've pointed out one more special age group, young adults. I have to say Croatia was one of the first countries in the European Union to introduce this new age group from 18 to 21. We introduced it in 1959, which is very early. Why? It is like a transitional phase to go from the criminal legislation for juveniles to general criminal legislation. So in our country, if a young adult commits a criminal offense, there is a possibility that some aspects of juvenile criminal legislation will be used in his case. So when we are speaking about our current criminal legislation regarding juveniles, I always give a brief overview what international and regional documents have affected our national legislation. I have to say there is a number of different international documents and they all have their importance. I have only highlighted some of the most important. In my personal opinion, one of the nicest international documents regarding the rights of the children is the guidelines on a child-friendly justice. It covers different aspects of and elements of a child as somebody who has committed a criminal offense or as a victim. It is a very good international document. So here I'm stating the Convention on the Rights of the Child and all these other United Nations international documents. We have implemented them into our legislation. From the Convention, Article 37, Article 40 is important if you look at the children in criminal legislation. Also, we have to mention the EU documents, since Croatia is a part of the European Union from 2013. And as you can see in the Treaty on the European Union, one of the objectives of the EU is to promote the protection on the rights of the child. In March 2021, European Commission made the UN strategy on the rights of the child. And one of the aims of that strategy is to achieve a child-friendly justice. But the EU took a step further and made a EU network for children's rights that also exists, and it officially was launched in the March of 2022. So the EU also considers all children's rights are the same as human rights. In our perspective, from the state of our current work, I think that one of the most important international documents from the EU is the directive from the 2016. Why? Because it is the first document that gives minimum rights of children who are suspect or accused person in a criminal proceeding. As you can see, the directive defines the child to be every person who is under the age of 18. The directive did not say one word about the age of criminal responsibility. Why? Because the EU member states could not have a unique opinion about that, and that is why they decided we're simply going to mention the lower age limit regarding the children. What is the aim of this directive? This aim is to ensure that all children who are suspect or accused person in criminal proceeding are able to understand and follow the proceeding in order to exercise their right to a fair trial. Now you have to connect the right to a fair trial with the Article number 6 from the European Convention of the Human Rights, and I also have to point out that everything that the European Court of Human Rights does in its case law, it can also refer to children. I will not present to you that today because that is a very long part of legislation. This directive was implemented into Croatian legislation and in 2019, which resulted in a new procedural rights for children in our criminal legislation. So, as you can see, so far we are doing very well. We have implemented everything that from the international documents, all the standards, but the question is how it refers to our national legislation. So, as you can see, our Constitution proclaims and says that all rights in the Constitution also apply to children. And here I have only listed some of the public law legislation that refer to children, but I have highlighted the most important from my aspect, from the aspect of criminal legislation, the Youth Courts Act. So that means that Croatia has a special legislation that deals with juveniles in all the aspects regarding criminal legislation. When a child has committed a criminal offense, or on the other situation, when a child is a victim of a criminal offense. I think that this Youth Courts Act, it has a really long legacy history in Croatia. A first glimpse of this type of legislation, we even had it at the beginning of the 20th century. Our current Youth Courts Act was implemented into our legislation in 1997. In 2011, we made a new Youth Courts Act, and the last amendment was in 2019 when we implemented the directive from the European Union. So, next, I would like to point you some aspects and some rights of the children from the Youth Courts Act. First, you see that I have divided this slide into two pieces, into two parts. Why? In this first part, you can see what is our legislation. What does the Youth Court consist of? It is a substantial criminal law, and there you can find juvenile sanctions that can be implemented, that can be imposed on children who have committed a criminal offense. All of these juvenile sanctions are based on a special prevention, and they're very flexible, and they're based on the principle of individualization, proportionality, and subsidiarity. We have a long list of educational measures so that our judges have a good way, so that they have enough sanctions that they can choose from. Why? Because every sanction needs to be individualized to a specific juvenile, which is in that case. So we have 8 educational measures, from judicial reprimand, special obligation, and haste, care, and supervision. Those 2 are the most popular, which means that they are the ones who, in 30% of cases, the juvenile will be sentenced to enhanced care and supervision or to a special obligation, sometimes even in combination. But also we have referral to a disciplinary center, referral to an educational institution or a special educational institution or a correctional institution. So you can see we have some educational measures outside of institution and some who are conducted inside our educational institution, who are a part of our social system. Juvenile imprisonment is the harshest punishment that the juvenile can receive in Croatia, but he has to be older juveniles, and we consider juvenile imprisonment to be the sanction of the last resort. In many cases, the judges won't impose juvenile imprisonment. They will use the suspended sentence for juvenile, a special suspended sentence of a juvenile imprisonment. So everything on paper looks pretty good, but if you look at our practice, we've looked at different reports from different bodies, and we found out, and we also look at our court practice, we could see that there is an uneven judicial practice in imposing juvenile systems. I have to say that we have problems in our social institutions, which means those educational institutions and also our correctional institutions. There's a lack of specialized personnel who are willing to work with juveniles. And as we can see that material and spatial conditions for the execution of these institutional sanctions are not very well, because we lack some of these elements mentioned before. There's a case overload for the social welfare system. I really have to say that they have too many cases in their hands, and that also reflects on the way that these institutional sanctions are being implemented in practice. So far, we have also found out that in some cases, the children lack the support from their parents. Why? They are not involved, which means that if you are dealing simply with a child and not with the family or with the parents, the result will probably not be the best. So if in any cases the parents have to be involved. We have a new institution, specialized foster care, and we're still going to have to see how this will be implemented in practice. I also always have to point out that we lack preventive and post-penal programs for juveniles. If we look at the position of a juvenile during a criminal procedure, so all this on the right side, the green side, are the rights that the juvenile in Croatia has in a situation when he's being a suspect or accused person in a criminal proceeding. So you can see the list is very, very long. Our criminal proceeding against juvenile is less formal. It is very flexible. Why? Because we have special courts who deal especially with juveniles who have committed a criminal offense. So they have to take into account all of these rights. Right to information, right of the parents to be included, right to an individual assessment, right to an assistance of a lawyer. Because parents and children, they usually are not fully aware what is going on. They need more information. They need somebody to explain to them, to tell them what is going to happen next. They're usually they're in fear what is going to happen next to their child. So somebody needs to explain it to them. As you can see, all of these rights are listed in our Youth Courts Act. It's very important to notice that in many cases, the juvenile do not come in front of the court. Why? Because in 40 to 50% cases every year is dealing with the measures of diversion, so-called principle of opportunity, which is very used in our practice, which means that the state attorney gives the juvenile informal sanctions. So everything is okay in paper, but we also have some problems in practice. There's a long duration of pretrial detention, and also there isn't any specific closed institution where the juvenile can go to pretrial detention. So we have also found out that in many cases, juveniles and their parents still do not receive the letter of rights, which means that they do not receive all the information they have to be known in a criminal proceeding. And sometimes the parents have expressed their worries because the defense lawyers who are put in their case ex officio, they are not specialized in working with juveniles. That is also one problem that we see is currently going on in practice. As I've said, I think for me the biggest problem is that we don't have a closed institution for a pretrial detention for juveniles. Our legislation says that we should have it, but our government says we don't need it. There isn't enough juveniles in pretrial detention. But if they go into pretrial detention during during criminal proceeding, then they cut off their education. They don't go to school anymore, and any kind of treatment program is not being presented to them. And I would like to finish up with the children who are victim of a criminal offense. Here is also everything that is regulated into our criminal legislation. We combine two acts, Criminal Procedure Act and Youth Courts Act. We considered every child to be a victim if it's not an 18-year, if it's under the age of 18. All of the authorities have to take into account the child's age, maturity, personality, and other circumstances. Why? To minimize the negative aspect and the negative consequences for that child who is a victim. All authorities must take into account the best interest of a child. So a child as a victim has all rights that all other victims in a criminal proceeding has, but they also have extra rights. And I have to point out this, that we have made rules for the interrogation of the children. As you have mentioned that you're trying to do that in your country, in Romania, we already have it. We have special methods and special ways of how to interrogate a child who is a victim. Our legislature makes a distinction between the children who are under the age of 18, under the age of 14, and these who are between the ages of 14 and 18. They're usually being interrogated by an investigative judge. Everything is audio-visual recorded. Why? In order to avoid multiple interrogations. So I think that we are going in a very good direction. Unfortunately, victims are still not informed about their rights. Written notification forms, they don't understand it. They are not adapted. In the terms of language, it's not adapted to children. I think that we should work on that. But we found out some positive results in practice, which means that we have a standardization in the method of the interrogation, standardization in the role and participation of professional associates, and we have a positive practice that all child victims are interrogated in the same way, regardless of their age. So this means that the practice does not make a difference between the children under the age of 14 and between 14 and 18 years of age. They usually try to conduct an interrogation under these specific rules and video recorded. And that would be my last. I just want to say this was really a brief overview. For more information, you're more than welcome to read our paper so that you would get a glimpse of our system. As you can see, everything is very well, but there is a room for improvement, and I think that probably one day we'll get there. Thank you for your attention.